not likely to get better anytime soon.
One big symptom of this is the Chinese currency, which is now hitting below 7, with 7 renminbi to $1. That's the real sign that China's got problems it can't solve.
And Chang puts the blame squarely on the Maoist philosophy of President Xi Jinping for weakening that country's economy. Breaking news and analysis at Town Hall.
The following program is sponsored by the law offices of Patrick L. Smith. This is the Attorney Patrick Smith Show. Get ready with your legal questions and call Patrick now. 877-943-9673. Again, that's 877-943-9673. The law office is open. And now your host, Patrick Smith.
Welcome to another edition of the Attorney Patrick Smith Show. I'm your host, Attorney Patrick Smith, and today is Saturday, June 3rd, and we will be with you for the next hour to answer all of your legal questions. 877-943-9673, 877-943-9673. That's your live and local studio line to reach us today and ask your legal question absolutely free of charge. 877-943-9673. And as always, you can email your question as well. That's patrick@attorneypatricksmith.com, patrick@attorneypatricksmith.com, or check out the website, attorneypatricksmith.com, and submit all your questions and request for appointments, booking us for speaking engagements directly through that as well. So attorneypatricksmith.com for that information. But we'd rather you call in and talk to us live. So 877-943-9673, open studio lines. Give us a call now. For those of you brand new to the program, I'm Attorney Patrick Smith, and we do this program every Saturday as a community service to you to answer all of your legal questions. So if you've had a legal topic come up this week and you said, man, I could really use some legal advice free of charge, this is that opportunity. Your answer to prayer right here. So give us a call now, 877-943-9673. So in addition to the usual gang here, we have a very special guest joining us, our regular guest, attorney Matt Kendall. Matt, how are you this morning, buddy?
Hey, doing good, Patrick. How are you today?
I'm good. And so Matt and I have been, gosh, it's been almost 20, can you believe we've known each other almost 20 years?
It haunts me every day.
I know. I was thinking about that. That means we're getting old. That means when we met, the interns weren't even born. I know. Right. Exactly. Let that sink in.
I don't feel that old.
Right. Exactly. So 877-943-9673. That's your live and local number to talk to myself or attorney Matt Kendall. Matt is a classically trained criminal defense attorney. And Matt, go ahead, do your introduction, give out your contact information for those parties listening here at the top of the show.
Yeah, so I'm a partner with the law firm of Bauer, Kreider, Kendall, and Perry. We are in Clearwater and Port Richey, Florida. I primarily work out of the Port Richey office covering Hernando, Pasco, Pinellas, Hillsborough, and sometimes Polk. I've even gone down to Key West, Vero Beach, handled cases as far there when I get called to do so.
So everybody, doesn't like to need an attorney, but when people do, in addition to needing an attorney for a will or a trust, the other common reasons people need an attorney for an accident, or they need an attorney to help them with some criminal trouble they may have gotten themselves into. And I was talking to my gorgeous bride about this, and I said, what's a topic that, would be helpful for people? And she suggested traffic violations. And that was actually your suggestion as well. So everybody kind of seemed to have the same mindset that what would be helpful to you, the listener, would be if we kind of went over common traffic violations, what to do, not to do, kind of some myths about traffic violations. So since you're here, let's just go ahead and turn it over to you. What do you advise a client, Matt, when you get pulled over, you should do what?
Well, the first thing you should do is just stay calm. Don't freak out. Just find a safe place to pull over. So if you're on the interstate and there's a big, concrete barricade next to you and you're pulling next to that, and that way you're maybe got an inch between your driver's side door and 75-mile-per-hour traffic going by, you don't necessarily have to stop right there. You can proceed in an orderly fashion and get someplace safe. So first, be calm, be safe. And then, once you pull over, when the cop comes up, there's no right or wrong. I usually tell people to keep their hands on the steering wheel. Don't start digging through the glove box. Wait till the officer comes up, addresses you, say, and, just be polite. They're usually going to be polite. as well. And so then just follow the commands of the officer and go from there.
So yeah, the research we did, everything you said, stay calm, hand over license and registration. I like to have it out handy. So if that happens, you have it in your hands on the steering wheel. I love that idea as well. I think it helps everybody's blood pressure just to see the hands and where they are. And I think staying calm is a good advice, because I've noticed a lot of times when we watch, on Patrol Live, the officers kind of give back what they get from whomever they pulled over. If you're nice and respectful, odds are this entire interaction is going to go well for everyone involved. So,
yeah, I usually say, and a lot of times the factors depend on the time of day as well. So if it's 2 a.m. and you're in a bad neighborhood, there's obviously more cause for you to keep your hands on the steering wheel and not start digging through your wallet or your pants or your glove box at that point. Whereas, noon or, rush hour traffic on a work day, it's probably less of a significant factor. But I usually try to say, hey, best practices all the time. That way it becomes routine and you don't necessarily have to think about it.
There you go. Just make it a habit, or just don't get pulled over. That's also an option.
Yeah.
So,
Ultimately, if you have it ready, you're saving 15 seconds on a traffic stop. That's going to last a couple minutes anyway.
fair enough. 877-943-9673. So you have a question for either myself, Attorney Patrick Smith, or Attorney Matt Kendall, who's here to answer all your criminal defense traffic violation questions. You can give us a call now. 877-943-9673. All right, let's go to Davenport, our home county, Imperial Polk County, Matt. Bill, welcome to the Attorney Patrick Smith Show.
Good morning. Thank you.
How can we help you, Bill?
Well, I have a will and a trust. Item 3 of the will says that residual assets will roll over into my living trust upon my death. I have a question about what that means. The idea is to avoid probate with all my assets. So some of my assets are jointly held, others have beneficiaries, others have POD beneficiaries. I don't know the difference if it's both the same POD and beneficiary. But the question is, if I have assets that aren't labeled either as joint ownership or beneficiaries, do those assets roll over into the trust upon my death and avoid probate?
Great question. So it's possible. So just to walk everyone down your question again, Bill, because there was a lot of moving parts. So you have a living revocable trust. You also have an accompanying pour-over will that funds assets into that trust should you pass away and not have the asset titled into the trust. The issue is the will only controls those assets that are in your name alone with no designated beneficiary upon your death. So it's a little impossible to answer your question 100% accurately, because you said you have some jointly held assets. So in a world where you die before the other joint account holder, that asset will not go to probate because it'll go to the other joint account holder, presumptively. However, if you flip the facts where the joint account holder died before you or with you, now there's a situation where that account can be subject to probate and controlled by your pour-over will. Pour-over wills are designed to capture unanticipated assets. So most commonly, it's the wrongful death settlement. So there's, for example, let's say you have a father who has 3 children, and very close to 2 of them wants to disinherit the other one and has an estate of, say, $500,000. And he has that $500,000 in his trust to avoid probate, which is always a great goal to have. But he passes away with no will, just the trust. And in his passing, it's a multi-million-dollar wrongful death settlement. Where does that settlement go? Well, in the absence of a will, it's going to go to the heirs at law, which would be all 3 kids. And that's not what the father wanted, clearly, based on what the trust said. But how do we tether an asset we didn't know was going to exist to the trust to make sure it's the same set of beneficiaries? The answer is the pour-over will. So it's designed to be a safety net. It's not something that we want to use, but it's there if we need it to avoid something called bifurcation of heirs, where there's one set of heirs at law and another set of heirs under the trust. The account that you mentioned that is beneficiaried, same answer. It's possible that'll avoid probate if the beneficiary you've designated, it survives you. But if they died with you or before you, then that account can be subject to the probate process. So there's a bit of what we call an order of death risk, Bill, and it's going to depend on kind of who dies last there. So if the accounts are non-qualified, meaning, they are pre-taxed accounts, those accounts are often best used and optimized by the trust by being funded directly into the trust. So if you haven't seen your attorney recently, maybe a good idea to go see your attorney. If you don't have an attorney, we'd be happy to sit down with you and review all that and make sure it's just the way it needs to be to optimize your family's protection.
Okay, I understand pretty much what you're saying. So if I have a joint account with my wife, of course, no problem if I predecease her. But if she predeceases me, then there's no designated beneficiary for that asset. In that case, that asset, whether it's a house or an automobile or whatever, will roll over into the living trust. Is that right?
Correct. So if you said you're married, how many years have you been married, Bill?
Oh, Lord, I forget. Don't ask me when my wife isn't there listening.
So I'm guessing it's been a while. Well, okay, so here's my point. For all these years you've been married, it's a situation where you've done a lot together. Do you have any children?
Yeah, we have 6.
God bless you. So, okay, so you have 6 children. You've raised a family together, earned a living together, made a life together. You've done it all together. I would suggest that you make these final arrangements together, because the last thing a grieving spouse is likely to want to deal with is going back and recreating things that you could have done now to take that burden off of a grieving spouse. And commonly,
we've done all that. I have a living trust and she has a living trust. We have joint funds and we have separated funds. So, but it's this one particular thing about the rollover will that I'm not sure. I'm reviewing everything and I want to make sure everything's right. I'm not quite sure what will roll over into the living trust and avoid probate. So if my wife predeceases me, our joint ownership of the house and some savings accounts will roll over into living trust. Is that how that works?
If not,
and also
if not jointly held with someone else or previously funded into the trust, yes, that is a potential probate asset.
Okay. Oh, that is. It's not. So if jointly held right now, if she predeceases me, that does not roll over into the trust without going through probate?
So if you have a house that's titled in just husband and wife's name, and she passes away, you're now the sole owner of that property. And you have the option of funding it into your trust and having it avoid probate, but it won't automatically avoid the probate process. Now, there is a process for which it can avoid probate creditors. And a lot of times people misunderstand that and think that's an avoidance of probate. But indeed, there are probate orders you have to get to effectuate that constitutional creditor protection if it's homestead property going to lineal descendants. So you have the opportunity to optimize things by getting it in the trust ahead of time.
Yeah, I was trying to avoid that complication, but so I was hoping that assets that don't have a beneficiary or joint ownership for one reason or another would all roll over, all residual assets, according to the will statement title 3, all residual assets roll over into the trust. Apparently that isn't 100% true.
Well, it is true. It is true, but the rollover through the will, remember, wills end in probate. So if it's controlled by that pour over clause to the trust, that is a passage or a ticket to the probate process. If you already have it in the trust on the date of death, then there's no need for the pour over will. Indeed, the pour over will is not designed to help someone sit back and be lackadaisical about trust funding to say, oh, at least I have a pour over will. No, what you want to have is the pour over will is there for a surprise asset, meaning you died and then you had a rich relative who passed away while you were in a coma and left you a $30,000 CD or something of that nature. It was something you did not expect to receive. You didn't have an opportunity to fund it into the trust. The pour over will is a last ditch effort to get it there.
Oh, I totally understand. That was a big help. I totally misunderstood what this what this pour over will does. I thought it avoids probate with the residual assets, but it doesn't avoid probate with the residual assets. They still have to go through probate, and then it rolls over into the trust for the distribution purposes.
Bill, that's what we're here for, to help you understand that. And I appreciate your kind words. So yes, at the end of the day, that is what the pour over will does, is it makes sure that things that should have been in the trust get there. And it's a lesson to you. You have the opportunity to avoid that, of course.
Yes. Okay. Thank you very much. What's your name, Patrick?
Smith. That's my name, Patrick Smith.
Patrick Smith. I had talked to Joseph Pippin on this radio station some time ago. I thought I'd be talking to him. He's the one who made up my will and assets. Do you work for him? Is he still in business? Oh, actually, I'm asking this question so that I can find another attorney if he's not still in business.
I do not. I have bad news to give you. Unfortunately, Joe passed away, but his practice is still in existence, and you can find them, and you're free to select any attorney you'd like to work with.
Okay, you have Patrick Smith.
All right.
And what's your phone number, Patrick?
877
Okay.
754 6764. 877 754 6764.
Okay. And where are you located, Patrick?
So we have an office just south of you there in Haines City, Winter Haven.
Okay, that's very convenient.
Yep.
Okay.
Right off
Thank
27.
you.
Bill, great caller. Appreciate you calling in.
Thank you very much. I'm reviewing this. I'll probably call you.
Bill, I'll look forward to meeting you in person. Have a great day, okay?
Thank you. Right.
All
Bye now.
Bye-bye. 877-943-9673 opens up a phone line if you want to talk to us now. 877-943-9673. I'm attorney Patrick Smith, and this is the Attorney Patrick Smith Show. Our special guest, attorney Matt Kendall, here to answer all of your criminal law questions, traffic violation questions. Maybe you were pulled over recently and you want to share that story about your interaction with law enforcement. And you can get some free legal advice regarding that now from attorney Matt Kendall, practicing criminal defense attorney. 877-943-9673. That's your live and local number to talk to us live on the air. Give us a call now. Brian, the call screener, standing by to take your call. 877-943-9673. And I gave out that office line for anybody else out there who wants to schedule a consultation. Again, that office line for any of our offices down in Haines City, Winter Haven, down in the Sarasota, Sun City Center, Clearwater area, 877-754-6764. Again, that toll-free office line, 877-754-6764. And you can, of course, call us today. Talk to us live on the air, 877-943-9673. While the next calls are getting queued up and screened, Matt, we have rights when we get pulled over, all right?
I've heard that.
Right? So, and we were talking about off the air, you've been pulled over before, but you're currently
Ticket free.
Ticket free. Never
Ticket
received
free.
a ticket, and that's a good feeling. And number one, you have the right to remain silent. Now, you have the right to remain silent to a certain degree, right? Because Florida, as we were discussing, is one of the 7 states where you do have to identify yourself if asked by the law enforcement officer, correct?
Yeah, you have to provide your license, your registration, your insurance information. But you don't have to answer questions about, where you were going, why were you going so fast. It's not really necessarily a right to remain silent as you would think of it under the Fifth Amendment, because you're not subject to any custodial interrogation pursuant to a traffic stop. But you don't have to answer any questions. It's voluntary to speak to a police officer.
And you can refuse the search of your car, correct?
Absolutely. Always do that. Even if you have nothing to hide, there's no reason for an officer without probable cause to go through your car.
So if you refuse the search, now in my mind, just thinking about it from law enforcement side, I'm calling for a dog.
Well, what I say is don't refuse the search, just deny the request to search. Obviously, if they tell you that they're searching, you should comply with the commands because you don't want to end up tased or something like that. And then we'll deal with it in the court system if something happens.
So if they say, hey, we have probable cause, we smell, and this is one of the issues too. We can talk about that. If someone gets the odor of marijuana, that is currently sufficient probable cause for a search?
Unfortunately, it still is, even with the adoption of medical marijuana. The appellate courts have, and I'm sure we're going to see more litigation coming on this, but the appellate courts have basically said that because marijuana is still illegal under federal law, it can provide probable cause to search. And kind of going back to what you mentioned, the dogs are trained on smelling the odors of narcotics. They don't actually smell the narcotics themselves, but the odors. So that's why sometimes they'll alert on a car and no drugs are found. It's because the odor is still present in the car. Well, the dog, when it alerts, can't differentiate between whether it's cocaine, marijuana, or methamphetamine, whatever. It just alerts for one of the scents that it's been trained to alert for, and that gives the probable cause.
Makes a lot of sense. And we talked a little bit, and before we go to our next caller, we talked about refusing field sobriety versus refusing a breathalyzer. So on a suspicion of DUI stop, There is a massive difference in outcome if you refuse field sobriety tests versus refusing a breathalyzer. Maybe speak a little bit to that.
So under Florida law, we have what someone mentioned was the implied consent program or complied consent law, meaning that if an officer has reasonable cause that you were driving under the influence, then he can request you to submit to a post-arrest breath test. Not pre-arrest, it's got to be post-arrest. So you're already under arrest by the time that you're giving this breath test. And if you refuse to give that breath test, he's got to read you what we call implied consent, meaning that, under Florida law, you have, if you fail to take this test or submit to this test, your license is going to be suspended for a period of 1 year. And, if you've previously refused, it could be 18 months or it could be a misdemeanor. So if you refuse, those are the things that are going to happen to your license, is that you're going to lose it for a year. If you blow over, which they don't tell you this, you're going to lose your license for 6 months. So either way, if you're going to blow over or you refuse, you're going to lose your license. Now there's ways around that. That's complicated, but we can challenge that afterwards within 10 days. But as far as field sobriety exercises go, if you refuse those, there's no really administrative or adverse consequences to that refusal. Just the officer can say, hey, to the jury at a trial, I asked them to do field sobriety exercises and they refused to do so. Now they can't do that unless they advise you of the adverse consequences, meaning that if you don't submit to these field sobriety exercises, I'm going to have to make my decision based upon the observations that I've seen so far, or that I'm going to arrest you if you don't do it. They got to give you some indication that there's going to be some issues or some adverse consequence for your refusal. But I usually recommend not to do field sobriety exercises because they're just, I think they're just kind of patently unfair.
But field sobriety, fine. And it does seem kind of arbitrary, sort of just in first pure person empirical research, watching these interactions, the tests kind of have an array, and it can be, recite the alphabet backwards.
Well, they're standardized field sobriety exercises, and that's not one of them.
Who writes these standardized field sobriety?
So the short answer is NHTSA, the National Highway Traffic Safety Administration, developed these over a period of time. So kind of what you referenced with the alphabet, there were officers all over the country were using different things like picking up quarters off the ground, reciting the alphabet backwards. So they got together, they did these studies, and they came up with some standardized exercises. And these are the things you're typically going to see, like walking a straight line, what we call the walk and turn, the one leg stand, and horizontal gaze nystagmus. Those are the three standardized ones that are primarily used. The horizontal gaze nystagmus is simply them checking your eyes. I'm not going to get too much into it, but they have to really be specialized in order to testify to the observations on that. The next one's the walk and turn, where you walk heel to toe down a straight line with your arms down by your side. You got to remain in the starting position for while they go over the instructions. You got to make a series of small turns. Now, these are supposed to test your normal faculties. Well, when you walk normally, you don't walk like that. So they're asking you to do things that you don't normally do. And then they say, well, that could tell his normal faculties were impaired because he couldn't do these things.
Yeah, great point. How often do you walk in a straight line and count to 10 and then immediately turn around and turn on the heel? And never.
Well, like I say, it's making a series of small steps. And, and then there's things like you can step off the line a little bit, but they count you, even if they don't use that margin of error. You don't actually have to touch heel to toe. You can leave a little bit of space, but a lot of officers forget that whole training experience and count you off for it. And then, they like the one leg stand, it's just standing on one leg, looking down at your foot 6 inches off the ground while you count to 30, and it's a timed exercise. And that's not something most people normally do either. You're supposed to take into account your age, your physical abilities. They typically ask some questions ahead of time. So, I usually advise clients not to do that. The breath test's a little different.
Mm-hmm.
I'm hesitant to advise people not to blow because the law requires you to blow.
Mm-hmm.
And I would never advise a client not to break the law,
Mm-hmm.
but I do it. But it's easier to defend a DUI in most instances when there is no breath test.
There you go. From the horse's mouth, guys, what to do. 877-943-9673. And of course, no one here advocating drinking and driving. Of course, always drink responsibly. And if you have any alcohol at all, our opinion is, of course, call an Uber, have a friend drive you home. Do not attempt to operate a motor vehicle if you've consumed any alcohol.
Yeah, and the other, I would say, and if I just might jump in, is don't fall asleep in your car with the keys in the ignition and the engine running.
Well, and that's a myth too. Let's pause there because I want to get to Fred's question, and we'll come back to that because I've heard all kinds of answers all over the place about putting the keys in the trunk and different things. So we can explore that a little more right after Fred's call. Fred, you've been very patient. How can we help you today? Welcome to the Attorney Patrick Smith Show.
Good morning, Patrick.
Hey, Fred.
Yes, I was wondering how long after your parents pass away, it's been 8 years, does the trust become inactive?
Well, typical trust terminates upon the final distribution to the final heir. Now, ultimately, that is going to be hemmed in by something called the rule against perpetuities. Do any of the interns want to take a stab at repeating the rule? No? Okay. So the rule against perpetuities is basically how long a trust can go. I'll spare you the actual rule because it'll just put you to sleep, Fred. Basically, your trust can't go on forever. There's a terminus to it. And the common law rule is based on lives in being, meaning who's actually alive when the trust goes into effect upon distribution. You can basically last all of those lifetimes. And then after the last person dies who's named, you got another 21 years to do the final distribution. They changed the statutory rule here in Florida a couple of years ago, and now I think it's up to 1,000 years, if I'm not mistaken. So you've got a long time to have a trust go on, but most trusts don't come anywhere near that. And there's exceptions to those rules, of course. The trust, do you have a copy of it handy by chance?
No, I don't. But
Okay.
are you saying that the remaining children of the named in trust, that it can go on for 21 years of the children?
Yeah, so let me describe it to you. So this could be a situation where you have 3 children, A, B, and C. C's
Right.
the last one to die. Upon C's death, mark 21 years. And it could go on theoretically another, and it could go further than that. And in old school, old school, attorneys would commonly just put a list of baby names in the documents. And they would do that not because the babies were interested parties as beneficiaries. They were getting advantage of measuring lives, and they would just have these young children's names in the document. And that way you're theoretically pushing out the final date of that ultimate 21-year expiration. But most trusts come nowhere near that. I mean, most people are saying, hey, distribute it to my friends, family, church, or whomever, and do it as quickly as possible. So usually it's as long as it takes to pay creditors, send out the requisite trust notices, do a tax filing, accounting, and distribution. That can all be done pretty quickly. But the grantor, the trust, has the right to say something like this. So instead of the parent saying you get it outright, you get the benefit of the trust proceeds over your lifetime. And then the trustee monitors that inheritance for you. So you're not getting it outright. It's going to be there and available to pay your bills and help you live your best life throughout your lifetime. So it's going to go on for years.
So after a parent's death, a trust can stay active.
Yes. And you're going to live and die, no pun intended, by the terms of the trust. So we have to put eyes on the trust to tell you whether or not it's being properly administered or if there is some sort of breach of the duty of prompt administration. But without putting eyes on the trust, Fred, there's no way for us to know the rules that they're playing by.
I see. Okay.
Great
All right.
question, Fred. What station are you listening on?
It's 860.
860, the answer. We appreciate you, Fred. Enjoy the
Local.
rest of your Saturday. Amen.
Thank you. Love you guys.
All right. Thank you. Bye-bye. All righty. 877-943-9673. 877-943-9673. I'm your host, Attorney Patrick Smith. This is the Attorney Patrick Smith Show. With us, our special guest, Attorney Matthew Kendall, criminal defense attorney here in Pinellas, Pasco, Hillsborough counties. Peter, the intern, say the alphabet backwards.
I'm not even going to try that.
Okay, so this is my point.
What did he do last night? Huh?
Yeah, exactly. So Peter the intern, stone cold sober, and that's a difficult task sober. So that's why I'm saying I'm glad NHTSA has some regulations on this because I agree with you. They did sort of seem to be all over the place. Follow the tip of the pen. Okay, and it's just sort of how often do you find yourself following the tip of a pen with your eyes without moving your head? These are not normal movements. Now you mentioned something about don't fall asleep in the car, and this may be a myth. You can dispel the myth now. If you fall asleep in the car, but your keys are in the trunk it changes the facts versus the keys being in the ignition. Is that true?
Yes. So it's actually what we look at as actual physical control is what the statute says: driving or an actual physical control of a vehicle. So it can be any type of vehicle, a bike, a golf cart,
Lawnmower.
yeah, anything. So if the keys are in the back, it's easier to say that you did not have actual physical control, and that's the readily ability to operate the vehicle. Whether the keys are in the ignition, if the keys are in your lap, it's going to be problematic. I'm not saying these cases can't be reduced or worked out, because they're not very jury friendly when someone makes that right decision, not to drive. But if the keys are in the back, it's a lot better story, because now you have to look for those keys. But the first thing you want to do is, you're going to fall asleep in your car. What do you want? You want that air conditioning going. You want the heat going if it's the wintertime. Maybe you want the radio on if you like sleeping to music. So, but you got to, that's just not a good thing. The best thing you said to do is just call an Uber, or
Be responsible.
the other option is, maybe crack the windows a little bit and throw the keys in the back.
So let's law school this thing for a second. Let's play law school for a second. So now, instead of the keys being in the back, you're in the back seat, but the keys are in the ignition.
So I think that's going to be good for you as well, because you're not going to have the ability to operate the vehicle from the back seat or the passenger seat. So as long as you're outside the driver's seat, or the keys, you're going to want to have some, something away. Either you or the keys are not going to want to be around the driver's
You're
seat.
in the driver's seat, keys are on the dash.
That's going to be a little bit better.
A little bit better.
Yeah.
So you want to, it's a degree of, are you in control of a vehicle?
I'd say how close the keys are is important. So how far you have to reach for them. Obviously the keys show that you put them up there. You put them up there intentionally. So you're showing that, hey, I had no intention to drive this car. I threw them up there. Whereas if they're in your lap, that say, you could have been fumbling around and you passed out or something like that. So
If they're in your pocket.
So intent is not necessarily an element of the offense, but I think when people look at that, if you have to be in a jury trial, if you can show what your intent was, that's going to be a good fact in your favor.
So we look at common defenses.
So, this is a totality of the circumstances type scenario where
Sure.
they're looking at, they're not one fact is necessarily going to control the day.
Well, and that's where criminal defense attorneys make their living, is in these totality of circumstances and in the facts, and then, ferreting out where, were the keys 6 inches away? Were they, on the other side of the dashboard closer to the passenger door? That's where it is going to come down to. That's the crux of the case. But there are certain defenses that people often, promulgate about traffic violations. And one is about if the officer simply doesn't appear. Now that'll work on like a moving violation or simple traffic, but not on a criminal citation. Maybe speak a little bit to that.
Well, in any case, whether it's a traffic case or a criminal traffic or civil, they have to be able to prove the elements of the offense beyond a reasonable doubt. And so one of those is always going to be the identity of the person involved. So like in a traffic crash, a lot of times the other driver is not going to be able to identify the person that hit them for whatever reason. And so maybe because they've never seen him before, maybe because he just looks like a regular person, whatever. So it's going to be a cop that's going to say, hey, this person pointed me out to this person being the driver. I identified that person by their Florida driver's license. So sometimes without the cop appearing for that reason, even though he didn't witness the accident, he's necessary to prove the identity of the driver. So without him, the case will get thrown out. Now, in a criminal case, they still have to prove identity. So a lot of the time they put the witness on the stand and say, sir, do you see the person that hit you, or the person that drove from the scene, or the person that did X, Y, Z? And they're like, yes, Your Honor, that's him. Can you please describe an article of clothing that he's wearing? And of course, they're going to pick the person that's sitting next to the defense lawyer, but that's kind of the way it goes. So the cop is only necessary if he's needed to prove identity or an element of the offense.
Well,
and same with any other witness.
So 877-943-9673. If you have a criminal defense question for Attorney Matt Kendall or any other legal question, we're here to help. This is Attorney Patrick Smith, and you're listening to the Attorney Patrick Smith Show. We have offices throughout the Central Florida area to better serve you. To schedule an appointment at any of our office locations, 877-754-6764, 877-754-6764. But we'd love to talk to you live. So give us a call now. Open phone lines, 877-943-9673. And you can call in with your legal question, especially if it's a criminal defense or traffic violation question. We have Attorney Matt Kendall here to help you out today. 877-943-9673. And the other issue that comes up is the calibration of the radar gun. and there's requirements that they have to be recalibrated. How many times would you say, percentage wise, in traffic cases, traffic violations, has calibration been a reason for exculpation of your client?
So very few actually. So usually the officers that write the tickets, whether it's the highway patrol or those assigned to traffic duty, are trained to keep their records and to do their calibration. So that's what they focus on. Typically, it's not just some officer that's, pulling somebody over randomly. So typically it's going to be, oh, they didn't show up to court with their documents. So they have to bring the documents to court so that we can look at them or they can enter them into evidence. So a lot of times if we're going to win on that, it's because they just didn't bring the proof to court. But typically they're pretty good about keeping everything, at least following the statutes and the administrative rules as it relates to calibration.
A few myths before we get to something that's a little more lighthearted. Signing the ticket is an admission of guilt. This is a myth.
That is myth, yes.
Yeah. So it's not true. It's simply showing that you received the ticket. It's acknowledging receipt.
Correct? And it can be a crime to refuse to sign or accept a summons if it's a criminal traffic.
What I was about to say, that's a great way to make it go from bad to worse.
Yes.
And that's a situation that could escalate quickly. And that's clerical errors. A lot of times people think that if, the address is off by a digit or your name's misspelled, that somehow that's going to be exculpatory for you. And that's simply not the case. The Leos are given room to be human and make simple errors like that.
That's correct. Most judges are not going to throw it out based upon that. And they can amend the ticket at any time prior to the hearing.
And here's my favorite: matching traffic flow. I was simply matching the speed of everyone around me. That is not a defense.
So when you go to traffic court, sometimes some judges always give a little open, I don't call it a colloquy or a spiel about, what to expect from your traffic hearing today. And some judges will say, listen, if you plan to tell me that you were just going with the flow with traffic and it wasn't fair that the officer just picked you out, she's like, that's not a defense to this charge. You just happen to be unlucky that day.
So how many times have you gone to court and, volleyed very real defenses and then heard laypersons unrepresented by counsel get up and attempt to repeat the words that you said?
Well, I'm not sure I follow your question.
So you get up and ask for a withhold of adjudication.
Okay.
How many times do people get up and try to repeat a phrase like that? Have you ever heard that?
Hey, I'm sure I have. Usually when my cases are done, I'm out the door, but sometimes the judges will advise them, when they come in there, like if you're looking just to keep points off your license and you want to resolve your case, just let me know. And, when you plead, I'll look at your record and decide.
All right.
But they just tell the judge we don't want points. And that's what, in a traffic ticket, that's basically what a withhold of adjudication.
Yeah, I guess
is.
my point is there, if you go to court and you're not represented by counsel, don't try to be a lawyer. Just level with the judge. And I mean, obviously we recommend having counsel represent you, but if you're not going to, don't try to pretend to be a lawyer. I don't think that goes over well for anyone. I think it's best if you just be honest and, tell your story.
Well, yeah, if you're going to pretend to be a lawyer, at least look at the rules and know what you're doing, because you are going to be held by the same standard as the lawyers. I will say the rules of traffic court are a little lax. They're typically not recorded in most jurisdictions. There's no record unless you choose to bring your own court reporter or make your own record. But if you want to get evidence in and you want to bring in videos or you want to talk about pictures, you got to bring them.
Yeah.
And you got to, if you hire a lawyer, your lawyer's going to know what to do and how to prepare for that hearing.
A colleague and friend of mine was pulled over on a traffic citation, and he spent weeks taking pictures of the intersection, having it blown up on a chart, and went through all that time and effort just for the principle of arguing and won. But, he brought the evidence. He brought it in. He put the law enforcement officer on the stand and took his testimony and basically got the officer to admit that he may not have seen what he saw. And, then of course there's reasonable doubt there at that point. So 877-943-9673. This is the Attorney Patrick Smith Show. And I'm your host, Attorney Patrick Smith, along with our special guest, Attorney Matt Kendall, criminal defense attorney. Let's go to Apollo Beach next. And we're going to talk to Michael. Michael, welcome to the Attorney Patrick Smith Show. Hey, Michael.
How are you doing?
Great, Michael. What station are you listening on?
1025 The Bone.
We appreciate all you Bone listeners out there. Michael, how can we help you?
Well, I'm changing gears again back to a trust, and my question is, or actually, I have two. If you got time,
sure.
I'm thinking about putting some properties into a trust, and my question is, in their income-producing properties, does that income have to stay in the trust? And then my second question is, how long does the trust have to be active before it's not able to be attacked by like an illness? Like say I get injured or ill, and then a hospital might want to come after the trust to dissolve it.
Yeah,
How
I
long
feel-
does it have to be with it?
Yeah, I feel like you're dancing around the 5-year look back question. Is that what you're doing, Michael?
Yes.
Yeah. So, I mean, I don't know that the 5-year look back is going to be relevant for this particular type of trust. I mean, that's more like nursing home or asset protection planning for someone going on Medicaid. So if you're doing asset protection planning from a rental property perspective, are the properties free and clear, by the way, of any mortgage or encumbrance?
No,
All right. So
not yet.
So the only way you can get them funded into an LLC then will be with the lender's permission. So be aware of that. But that's probably the best thing to do. Pay them off, put them in the LLC, or get lender's permission to fund them into an LLC. And there's going to be your liability protection. That's going to hem in those liability producing rental properties. But make sure you consult with an attorney about that. Too many people think that creating the LLC is all you need to do to protect yourself. It's an important part and it needs to be created correctly. But how it's maintained after that creation determines how protected you are from something called piercing of the corporate veil when a plaintiff sues you. So if it's been a while since you've met with your attorney and gone over those facts, Michael, get in with them. And if you don't have one, we'll be happy to meet with you and get you squared away on kind of how to optimally position everything.
Well, once they're in a trust, if they're producing income, can that income be pulled out of that trust?
Yeah, you can pull it out. That's according to the terms of the trust that you established. The only way it couldn't be pulled out is if you said any income that goes in can't be distributed. But that would be a weird thing to do.
Okay, that's what I wanted to know. Thank you,
Michael. We appreciate you. Have a great Saturday. Okay.
Yep.
All right. 877-943-9673. Michael hanging up, open up a phone line for those of you trying to get in. 877, and it's already full. 877-943-9673. Attorney Patrick Smith, along with attorney Matthew Kendall, who's our resident criminal defense attorney. And speaking of criminal defense, let's go to Venice, and we're going to talk to James. James, you have a probable cause question for attorney Kendall, correct?
Yes, I do.
All right.
So I'm just curious. Thank you for your time, gentlemen. I was just curious when a traffic stop turns into a criminal, like I said, and when they have probable cause, I'm not understanding how they pulled over a friend of mine where they said the taillights were out, and right away it went from a traffic to a criminal case because when she opened up her wallet, there was a small amount of drugs. I guess she got the wallet somewhere from a friend and didn't know anyway. But there was drugs in the car, and right away, so it turns from traffic to criminal, or is it still traffic?
Well, yeah, so it can be both. Obviously, it turns criminal once an officer develops a reasonable suspicion or a probable cause that a crime is being committed. So, that can be anything from, they run the tag and then the driver looks like the registered owner and they have a suspended license. So it could start that way from the outset. As you kind of mentioned, it sounds like the officer may have observed some suspected narcotics in plain view. Now that's going to have to be based upon his training and experience that he can immediately recognize the illicit nature of that substance. It could be, when the window rolls down and they smell the odor of marijuana emanating from the vehicle, or it could be from a number of things, but those are some of the most common ones. So I don't know if that answers your question, but it's really based upon the facts and circumstances known to the officer in light of his training and experience is kind of how probable cause gets defined.
And James, the takeaway there is it's not a bifurcated matter. There's not a dichotomy here. It's not either or. It can very much be both.
But it starts out as traffic, correct?
Many times it just starts out as a traffic offense. Many of our cases simply start that way, whether it's a vehicle malfunction issue like the tag lights, whether it's a moving violation. That's how they start. That's how the interaction with law enforcement officer occurs. It's not criminal in nature, but through that investigation of the ticket, the officer develops probable cause or reasonable suspicion that a crime is being or about or was committed.
But it could start as a criminal matter. For instance, if they run the plate and the car comes back stolen, we're not dealing with a traffic stop, are we? We're dealing with a criminal investigation at that point.
Correct. The car would likely be, it could be stopped for a traffic violation as well. But yeah, then it's going to start out as a criminal investigation. Correct.
So Jeff, does that help? Or James, does that help?
That does. It does. I appreciate it. Thank you, gentlemen, for your time, and love the show.
James, what station are you listening on?
102.5.
The Bone. We appreciate you, James. Have a great Saturday, okay?
Thank you. You too, man.
All right.
Thank
Bye-bye.
you.
All right. 877-943-9673. 877-943-9673. This is the Attorney Patrick Smith Show. I'm Attorney Patrick Smith alongside of Attorney Matt Kendall. And before we go to our next callers, Peter the intern outdid himself this week. We had an assignment to the interns of come up with a list of what to do when you get pulled over. And Peter the intern, demonstrating his thinking outside of the box, created that list and went on to go for extra credit and create a list of what not to do when getting pulled over. I'm reading this for strictly entertainment value, Matt. Number 1, what not to do when getting pulled over. Claim to be a sovereign citizen and tell the officer that you don't need a driver's license because you're traveling, not driving.
Is that number 1 or is that number
That's
5?
number-
Are we counting up or are we counting down on the
We're-
list?
that's
'Cause that's a
number-
good one. That's a good one.
Number 1 on the list. Oh,
They
this
came out strong on that one.
I think we're definitely working our way up, though. Wait till you hear number 2.
All right.
Number 2, what not to do when getting pulled over. Take your firearm out and slap it on the dashboard.
Well, he's now showing the officer that it's there. So, but that's probably a good idea. Just tell the officer you have one.
That's the rule on that. If you have a firearm, tell the officer, do not reach for it. They'll have you exit the vehicle more than likely. They'll secure it. Let them do their thing. Do
So,
not try to be helpful.
If you're a convicted felon, you don't want to do that.
And they probably know that. So. Number 3, and this is just a timing issue. Pull your wallet out of your back pocket as soon as the officer comes to your window. Yeah, they love sudden movements right as they approach. I guess that's a wise thing. No, as we talked at the start of the show, you want to have your hands stable and steady on that steering wheel and just remain calm and let them conduct their investigation.
That's what I do. Typically, an officer is familiar with the reach to the back pocket, but just keep it. You just want him to. You want him to be comfortable, right?
Yeah.
And that's kind of what you're going for there.
Or her. All righty. 877-943
or that.
Or 9673. 877-943-9673. You know who we haven't heard from is law enforcement. We haven't heard from any law enforcement to call. So if you're out there and you're law enforcement, you want to call in and talk about, your strategy when you do traffic stops, or where in your mind it goes from traffic to criminal or probable cause, call in. We'd love to hear from some law enforcement. 877-943-9673. All right, let's go to a very patient Jeff in Bradenton. Jeff, welcome to the Attorney Patrick Smith Show.
Hi, good morning, gentlemen.
Good morning. How can we help you, Jeff?
Okay, yeah, question. Basically, a 30-year-old child support case that's been closed for approximately 30 years. The ex-wife is threatening to reopen it. Now, there are some monies due from way back, and I could not imagine to tell you how much. It's not a lot, but she's, again, threatening to reopen. I was just wondering if that's it, if she can do that or not.
Well, I'm going to turn this one over to Matt because a lot of people don't know this about Matt. But in his former life, before his criminal defense days, he actually did masquerade as a family law attorney, correct? So, Matt, this one's all yours.
So I think she can enforce. It's been a while since I've done it. So I would say, 1, wait till if she actually does, is she trying to negotiate with you to get some of the past due or the arrears or what's going on?
Well, no, not necessarily. She just called me one day out of the blue and just basically tried to, what's the word for it? Well, she just wanted me to start paying her some monies every week.
Is the word you're looking for
her?
Is the word you're looking for extort?
Yes. Thank you.
Okay.
Well, so if it's a judgment for support and it's in arrears, it's still a judgment and it's I guess vested, so to speak, and she could attempt to recover those monies. Whether she can reopen a case to hold you in contempt to do that, I'm not sure about that. I would wait to see if that happens, but it's money that you owe civilly. So, for instance, let's say you won the lottery and you went down to collect your winnings, and they see you have this old child support judgment. They're going to make sure that some of your winnings is going to go to that judgment. So technically it could still be out there and they can still collect.
So Jeff, I got to run through some calls. I'm going to have Matt give out his information. You can call him at the office next week and try to convince him to dust off the family law practice. Okay.
Absolutely. Thank you.
You're welcome, Jeff. All right, Matt, go ahead and give out your contact information quickly, buddy.
Yeah. So on the website, it's floridadefense.com. Florida spelled out, 727-446-4800. Bauer, Kreider, Kendall, and Perry.
Or you can just contact my office and we'll be happy to put you in touch with Attorney Kendall. Our office line 877-754-6764. Next, we're going to go to Joe in Tampa. Joe, I have about 30 seconds. Can it be quick?
I was wondering how much does it typically cost on average to create a trust? I'm talking about my parents' home property and an industrial property in Drew Park. Just a couple of properties. How much would it cost to put that into a trust, you think?
My standard trust package for a non-taxable estate, meaning less than 12.9 million, is $695, and that's for a single person or a married couple doing the same plan, and that covers trust, pour-over will, power of attorney, healthcare surrogate, living will, and the deed. We use written fee agreements for all that. Each additional deed is $250. So, Joe, we publish our rates. You can call the office; they'll send you a rate sheet. But great question. We appreciate you calling in.
Thank you very much.
Thank you, Joe.
Your time, gentlemen.
Thank you. All righty, Matt, thanks for being here today. Thank you,
Thanks
Amiko.
for
Thank you,
having me.
Brian. Good job, interns. And Matt, you'll come back and join us again soon?
Absolutely.
All right, we're looking forward to it. Those calls, hold them. I'll talk to them off the air, guys. This is the Attorney Patrick Smith Show. I'm Attorney Patrick Smith. Reach me at the office, 877-754-6764. Everybody stay safe and God bless.
The preceding was sponsored by the law offices of Patrick L. Smith. W282CI Tampa, W271CY Lakeland, W262CP Bayonet Point.
Online at letstalkfaith.com or listen on TuneIn and Odyssey.
Need a good shot of your favorite pastor? Well, you can get him anywhere and everywhere